Don McCrea, PhD, is currently president of Your Business Legacy, a consultancy focused on coaching family and small business owners to a successful exit from their business when they retire. He has over 30 years of consulting experience with both small businesses and global corporate businesses, developing custom solutions to a variety of business problems in many different industries. Don has previously served as consultant to UC Berkeley's College of Engineering as Director, Strategic Alliances, and UCLA's Anderson School of Management as Director of Custom Solutions for Executive Education Programs. He has 30 years of experience with Fortune 100 computer companies, NCR Corporation, Unisys, Digital Equipment Corporation, and the Department of Defense as a senior consultant, systems designer, senior systems development manager, product manager, and senior marketing and sales manager. He holds a PhD in executive management from the Peter F. Drucker Graduate School of Management at Claremont Graduate University and an MS in mathematics from the University of Michigan. His AB degree in mathematics is from Humboldt State University. Don can be reached by email at don@yourbusinesslegacy.net. And there's additional contact information, and he's always welcome to receive any questions you may have.
Hello, everyone, and thank you for attending today's seminar. Today, we are going to be talking about succession planning and its importance to the modern day law office and to the modern day attorney. Now, just a couple of months ago, the State Bar of California issued a standing committee on professional responsibility and conduct, issued the formal opinion in number 20-0002, which is the conduct and formal opinion about the ethical obligations to engage in succession planning. And it's becoming a growing importance to attorneys and to the attention of the State Bar that there needs to be formalized education and an effort for attorneys to actually get MCLE coverage and education as far as having succession planning in place. And this is because of rules 1.1, 1.3, 1.4, 1.7, 1.9, 1.5, 1.6, 1.8, and 5.1 of the rules of professional conduct of the State Bar of California. It also covers Business and Professions Code 6068, subdivision E1 and 6185. In other words, there's a lot of things that are involved in succession planning and the attorney's obligations as a professional to make sure that it's covered. Otherwise, there are a lot of things that can go wrong and a lot of things that lawyers would unfortunately do that would put their clients in a compromised position. Mainly that the State Bar is concerned that attorneys are need to adhere to things like the duty of due diligence, the duty of competence, the duty of loyalty, and the duty to communicate, and the duty to avoid reasonably foreseeable prejudice when terminating representation, the duty for safekeeping funds and the property of clients are all involved when an attorney sets up and properly or improperly executes the succession plan. Now, I myself have never closed my law office. I'm still in practice, but as Rule 1.3 states, if you're not an expert in something, you go find an expert to help you. And so I have found a real expert in Don McCrea with Your Business Legacy to talk to us today about succession planning for attorneys.
Russell, thank you so much for that introduction and for setting the tone for this. what I'd like to do here is really to go over what's involved in succession planning, why succession planning is so important, not only for small business, but for legal practices, and perhaps especially for legal practices because of your obligations to your clients and to your profession. So what we're going to do today is really go through what's involved in succession planning, why you should do it, when you should do it, the risks of not doing it, and what are the stages of succession planning, and how do you make sure your plan is really effective. The details of succession planning are something that are unique to each practice and something you should work with an expert on to help you develop. So at this point, I'll share the screen. So I'd like to call attention, particularly to the second title here, the ethical obligation requirements of attorneys to succession plan. That's a critical piece. It's part of your practice and it's part of your commitment to your clients. Now, a piece of this is, when do succession plan? Who needs it? Well, whether you're the senior partner in a practice, you're an individual in a multi-attorney practice, or you're just a single attorney practice, everything we discuss here can be applied to your role and position. And the need to succession plan is equally as important for every one of these positions. So this is a bit lengthy. I'm not going to go through the entire thing, but we'll look at what is it, why, the ethical moral responsibilities, the risks, and who should succession plan. We pretty much covered that, in fact. When do you start? What are your goals? What's the process? And how do you know it's going to work if you should have to invoke your succession plan? And then what's next for you in this whole process? So in a nutshell, succession planning is the who, what, when, where, why, how of who steps into your place if you have to step away from your practice, whether you choose to do so or it happens for you because you have either taken ill unexpectedly, or you may have stepped in front of that proverbial bus, or maybe you just want to take that 3-month cruise in the Mediterranean. And how does that happen and still serve your clients? So we've covered some of this, but basically it's really important that you succession plan. If your business has value worth preserving, if you want it to survive your absence, and as a practicing attorney, that's absolutely, I would think, the case. It's ensuring that your practice is sustainable even without you there for a period of time, whether it's a short period of time or a long period of time. And how do you make sure your practice continues to thrive and retain its value when you've stepped away from it, either short term or long term? And let me add here one other thing, and that is that your practice generates income for you and for your family, and for your children, perhaps for your parents, for your commitments in the community. And that's an important piece to ensure is retained, even if you step away from that practice, is your obligations to others. And that gets us into both the ethical and moral responsibility side of this. You have an ethical obligation to your practice. And Russell talked about that in the beginning and what the practice of law expects of you. But there's a moral obligation there as well to your clients, your colleagues, employees, your communities, and as I said before, to your family. So both of these have to be taken into consideration in order to make the choice to succession plan and why you should do that. But there are some risks of not succession planning too, and it's important to understand what those are. As a legal practice, you may have long-term obligations to key clients who are significant to the value of your firm. And if you don't have a succession plan, that may be some question. One of the questions that some of your key clients are asking you, particularly your business clients, who have to do their own succession planning. They're going to want to know that their key providers, service providers, also have their own succession plan. If you don't do that, your firm is of less value. If, for example, you choose to transition your practice to someone else, to sell your practice. If you don't have a succession plan in place, that transition is going to be much more difficult. If something should happen that you are all of a sudden have to step away from your firm, let's say it's an illness. With all we've gone through over this last 3 years, that's happening to many more people who didn't anticipate it. If you don't have a plan as to how that can take place systematically, you're likely to throw your firm into a real chaotic situation. You may lose key people who step away from your firm when they don't see that there's a way of really maintaining that practice. And then if you're in a multi-partner firm, that may lead to some conflicts with other partners as to who takes over if you're the senior partner. How do you manage that? How do you ensure there aren't the power struggles, which always get in the way of adequately serving your clients? And then finally, it affects your culture and may affect your firm identity. If you are not able to continue practicing and serving your clients as you have in the past, that can affect how you're perceived in the industry and with the clients that you serve. So we pretty much covered this, and the short answer to this is everyone should succession plan. When do you do it? If you're a startup, you plan it right from the beginning. If you're a successful and growing firm, if you don't have a plan in place, it's time now to go ahead and do that. And if you're getting ready to retire, this is a key part of your planned exit from your practice. There's much more to retirement than just the succession planning. Are you ready to retire? Do you have your estate plan in place? Do you have a financial plan in place, et cetera? But it is key, even if you're close to that age. So, as I said, when do you start? You start now, no matter where your practice is. So there are a number of goals that you want to accomplish with succession planning. And this slide and the next cover most of those. What's the period of absence? Ideally, you want to plan for a permanent absence because you never can fully anticipate when is the next pandemic going to hit and whether or not it's going to affect you. What if you step in front of that proverbial bus? Obviously no choice of your own. That's a permanent period of absence. You want to take that 3-month vacation and a cruise in the Mediterranean. You still want your firm to thrive in that period of time. And you need to start planning with enough time to implement that succession. So for example, you don't decide that you're going to leave tomorrow for that 3-month vacation without having done the succession planning that you have an actionable plan that will work. You also have to know what decisions and actions have to be made, and there's an extensive list of all of the things that an attorney has to pay attention to in transitioning their business to a successor, and that'll be one of the documents that's available in resources that are available for this. It's significant. You need to understand what those are and how to take them. You also need to identify what kind of leadership is required in your firm. If you're the senior partner, you're responsible for the other partners in the firm, for the interns, for the paralegals, et cetera. And how does that leadership happen with your absence? And then what advisors do you need, both personally and maybe in your practice? Have you identified advisors like your CPA, your bookkeepers? You may have a business consultant helping you understand how to expand your practice. Your successor needs to understand what all of those advisors and others are that are necessary if you're not there. And then continuing that, you need to address all the actions required in order to make that succession happen. And in talking about the roles of your successor and the advisory team, you really need to understand what are all of those roles and how qualified is your chosen successor or perhaps successor team to carry out those roles. Part of the work of succession planning is identifying what are those gaps in your successor's ability and qualifications to successfully take over your position in the firm. You also need to know when are you going to implement it and to make sure it's successful. What are the triggers? If you come down with an illness, that may be a short-term, it may be a very long-term illness. A short-term illness may not trigger your succession plan. The firm may continue to operate for a few more days, say a week that you're out of the office with a bad cold, as opposed to 3 months with something that's incredibly serious. And who makes that decision that you're going to just continue without invoking the succession plan, or you do invoke it, and all of the things that have to take place in when that happens?
Don, I have a question,
Sure, Russell.
and that is, in the case of a partnership, it's relatively clear, or there are options that one has to give the power over to somebody else. But what is your suggestion for solos, that don't have someone else that's an attorney that they're working with on a day-to-day basis? How do they transition out? And
Well, there's a couple of ways to handle that. I'm working with an attorney now here in Northern California that she had another attorney in the practice, but that attorney was only part-time, et cetera, not really in a position to move into that role. So she's in the position right now of looking to hire a senior associate attorney that can eventually she can develop into a partnership position, and then turn the management of the firm over to that individual. So that's one way of doing it. Another way of doing it is identify another attorney that has a practice very similar to yours and has the same values you have, the same way of dealing with their clients that you do, and the two of you work out the succession plan that you each become the other's successor. And that means that you've really got to understand each other's practice. You want the practices to be as close as possible to each other in the way they treat their clients, et cetera. So those are two ways of doing that. The third is that you can ultimately plan for a sale if that happens, if something like that happens. But again, you've got to take into account the same kinds of considerations, ultimately to serve your clients in the way that you have been serving your clients. That's part of the moral obligation that comes with it, is to have a successor or succession plan, even if it involves a sale, that ensures that you meet those obligations to your clients. Does that address what you were asking, Russell?
yes, it does. There's still going to be those lone wolves that just don't get along with anybody, or can't, have practices that are so, esoteric that it's hard to find necessarily someone's succession plan. But I think that at least making people aware that it's something that they have to start thinking about is a very important part of what this lecture is addressing. So I'm glad that you at least are going to start triggering things in people's minds to start dealing with that.
Sure. Well, let me make a couple of comments on that. One is, go back again, and if you're that lone wolf that thinks what I do is so unique, nobody can do this but me, go back and look at the risks of what might happen, what might result if you step in front of that bus. You're not going to plan on it, but it can happen. Who do you have obligations to besides your clients, the community? You may have family obligations, whether it's your significant other, your children, etc. The other I would say is don't let your ego and your self-importance get in the way of doing what's right. You may think that your practice is so unique that nobody could ever do what you could do. Well, that may be the case, but then what can you do about that? How can you bring in another experienced attorney who knows enough, who can learn enough about what you do to be able to act as that as that successor so that you meet your commitments, your ethical and moral obligations. So it sometimes we whether we're in business or we're in law or what the industry is, we sometimes have to bite the bullet and do what is the right thing to do, even if we believe it's going to be difficult to do. So the succession planning process, this particular chart has 7 components to it. We've talked about a lot of this, and we'll talk about some right now. The key thing to start with is, what are your responsibility, decisions, and actions? What do you do in your day-to-day, week-to-week, month-to-month role in your firm? Because your successor is going to have to take on most or all of those same responsibilities, decisions, and actions. They're going to step into your role, and they have to understand what that is and how you carry that out. Then identify who's a potential successor. Is it that attorney in a similar practice who could potentially step in to do the work that each of you could do for each other? Is it an attorney who's a potential partner, for example, or an attorney that you, senior associate attorney, you bring into your practice? Or maybe it's a team of people. Maybe you've got 2 less senior attorneys who together can take over that management of the firm and doing the work that you do. And if it seems like there's no one, then that's the time to start addressing what are your other options? How do you solve this? And ideally bring in someone who can help you do that. Then the next step is how prepared is your successor? And that's where the gaps analysis come in. How ready are they to make the decisions you make, to take responsible for the things you do, to take the actions that you do? And if they're not fully prepared, you need a process that in a fairly short amount of time, that's what the critical milestones refers to here, to really bring them up to speed on what is required to prepare them to step into your role. We've talked about a development plan. You need to implement that development plan over time. And then we're in the next few slides here, we're going to look at determining how ready is your successor and what else needs to happen here. So how do you know your successor's ready? They might think they're ready, but you need to validate in fact that they are ready. So here's some things that you can do. First of all, you want to test the readiness more than once. And I would start off with small incremental steps. Take a 4-day weekend, for example. But make sure something comes up during that period of time that your successor needs to deal with in that period of time. Take a week's vacation and make sure that you're in both of those cases, make sure you're available. But again, make sure that there are things happening during that period of time, whether it's a week or it's 3 weeks, that you know your successor is going to have to deal with. But make yourself available during that time, so if they have questions, etc., about it, they don't panic and make a poor decision. So it's really an incremental process to make sure they're ready. And then I suggested to you to find other ways to build your confidence that they're ready. Maybe at the end of that vacation, you have a postmortem question session. How did it go? What did you run into? What went well for you? What did you struggle with? Where do you need more help from me? And then there's a whole question of what triggers the plan. We talked about that a bit, and who makes that decision. Is it a vacation? Is it an illness? Is it a short illness? Is it potentially long illness? Or heaven forbid, is it a death? Do you end up or so incapacitated that you're no longer able to step into your role? And in each of those cases, you're going to invoke some element of your succession plan. Who's going to make the decision to do that? If it's a full turning over your practice, let's say to that you're a sole practitioner and it's turning over your practice to that other attorney that you worked out the process with, who's going to make that decision? Maybe it's your significant other who has been involved in your succession planning process, or maybe there's just a set of boxes to check off that if you check off all of them, it's time for that plan to be initiated. So these again are part of the succession planning process where you put all of the details behind this. And again, that's why it's important to work with someone who's experienced in succession planning to really help you identify in your unique situation what are all of these factors. And everything we're talking about is something that you can do yourself, or you can work with an experienced succession planner to help you do at least maybe all of it, maybe just the parts that you struggle with yourself. Sure.
So when someone works with you, do you already have like a list of like events, typical events that trigger plans that you've worked with in the past? So you've seen things that are typical to attorneys that would cause them to have triggering events or anything like that? Do you already have like a pre-made list to give ideas to attorneys to think about? Because maybe a lot of them don't realize, the attorneys that you work with, because maybe some attorneys I know have worked every day of their life, like their entire lives. They've never taken a day off, or they only taken weekends and holidays off, and they don't really think to themselves what a triggering event would really be. So do you have like a list of things that would typically bring up triggering events for them?
Well, I could certainly put that together, but succession planning is a consultative process, not a check the box process. And every single case is different. If it's a, for example, the attorney that I'm currently working with right now is 55. She said she wanted to retire when she was 62. She looks 35. She's healthy. She runs, she hikes, etc. I'm in the process of talking to another attorney right now who's in his, I believe, in his 60s. Their two situations are very, very different in terms of what can affect them, how it might affect them, what might trigger it, et cetera. And that's why it ends up being a consultative process, because it's each one is totally unique. I have an underlying process that consultative process that I use, but I draw from that as required for each unique situation. So it really is a collaborative process between the attorney and myself in working through that succession plan. And again, we work through what are each of us contributing to that succession plan. How much of it are we going to do? So to answer that specific question about the triggers for that individual attorney, I'll identify what are the specific things that might trigger you, given your situation, your practice, your family situation, et cetera.
Okay. Yeah, and I'm just curious how the other attorney that you're working with, how does it differ from the one that's super healthy and it wants to long-term plan versus the one that's in his 60s and is more, I guess, ready to retire right away? What are the significant differences between the two of them, other than just that? Does the other attorney have health issues, or?
The older attorney, I don't know enough about at this point, because we haven't begun directly working together and getting into the details. The younger attorney is considering transitioning over time to an of counsel position, so she's not fully leaving the firm. Whereas at least in the discussions I've had so far with the older attorney, he's ready to leave the practice, and so how his succession plan is, how is that going to actually happen? It's more of a full retirement planning than just succession planning. So a piece of what we're going to begin to look at is the nature of his financial plan, nature of his estate planning, how up to date is it, et cetera.
Okay. Very good.
All right. So this is coming to really to the end of what we're going to be talking about here today. And the real question is what to every attorney reviewing this, what are your next steps? And I encourage you to really go back, look at this presentation in detail, identify for you, what are your risks? Identify all the pieces that we talked about in putting together the plan. If you feel that you need support in putting together your succession plan, then contact someone like myself or someone else who does the succession planning, exit planning from your business to get the support that you need to be able to develop a detailed succession plan for your business. And my suggestion, as I said before, is start now. Don't wait, because you don't know when the next pandemic is coming, when the car doesn't stop at the stop sign, etc.
Now, we talked about the moral obligations, just in sort of, esoterically, but can you give more examples of the moral implications that come from the planning your succession plan? And maybe you can give some examples of times where you've helped clients fulfill moral obligations as well as just the business-based ones.
Sure. One business that I worked with before the pandemic hit is he was about to sell the business. He and his wife had an importing business where they the spices and teas that they imported, they sold wholesales to restaurants and stores like Whole Foods and so on. And I was introduced to him by his CPA. He had the first part of the discussion was, he said, I have two offers to buy this business and I don't know what's the right offer. And he described those a little bit, and we talked about it a little bit. He took me on a tour of the business, met his wife. There was the two of them that owned the business. Then we began to talk about their financial readiness to retire. And they were in their late 50s, early 60s. And the question I asked is, how are you going to support yourself in this lifestyle that you're accustomed to for the next 20 to 30 years? He didn't have a financial plan. He didn't have an answer to that. Well, they have children, and their children were, I think, in their late teens and early 20s, but they were still responsible for their children, for their schooling, etc. And they wanted to build something for their children long term, particularly with the rising cost of houses and so on. So they, from my perspective, they had a moral obligation to really do that planning and really lay out for themselves a financial plan that would support themselves and their children and grandchildren if it reached that point. So that's just one example, a little bit extreme, but I find there are financial plans that haven't been reviewed lately or updated with the current status of the business, for example, or with an inheritance, or with an extreme debt that arose because of healthcare needs, etc.
Now, do you work with, do you bring in a team of your own professionals to help attorneys, or do you try to work with the ones that they already have in place? Like if they already have financial planners, they already have estate planners, that kind of thing. Do you try to work with them to coordinate a plan, or do you feel it's better to, maybe for the law firm to have something completely different, to bring in different experts than their own personal ones? What do you think is better?
The answer to that's yes. It really depends. I'm working with a client now that they have just worked with an estate attorney to put all their assets into a trust, and they've done nothing more in terms of distribution of assets. They have 4 children, his, hers, and ours, or his, hers, and theirs. So there's some complications in the estate planning that really need to be addressed because they want to turn over the business. to the one daughter and her two partners. So it's a complicated situation. It really requires detailed estate planning. As I looked, and this is a conversation that I need to have with them since we've just begun working together. But as I look at the attorney that they used for the trust, it doesn't look like that practice is a comprehensive enough practice to really deal with it, because the attorney they're working with just does estates and trusts as one of many things that they do, as opposed to really focusing on estate planning. So there's a lot of questions that I've got that if it turns out that this attorney is really sufficiently experienced, and that's not for me to judge, but to be able to address those kinds of questions, then fantastic, let's work with that. My preference is always to work with the existing providers, whether it's a CPA or a bookkeeper or a financial planner, that they're really satisfied with and are working well for them. I don't want to try to replace that person. On the other hand, if they let's say they're looking at selling their business, do they need a professional valuation? Not just something that their CPA has put together for them, but a business with more assets really needs someone very experienced in business valuation. So I have individuals that I can call upon for that, for insurance, for estate planning, financial planning, etc. One client that I've just begun working with is there's an opportunity to bring in, I think, five or six different individuals to work with them in various aspects, including something like documenting all of the business's processes and procedures, because they're not documented, and yet the daughter that's going to be taking over the business needs to pull all of that stuff out of her parents' brains and make sure that it's there once the parents step back from the business. All of, whether it's a small business or a larger business or a law practice, all of this is equally relevant.
I also, since you have not all of your clients are attorneys, obviously attorneys aren't someone that you specialize in. In your thoughts, what makes it different to set up a succession plan for a law office or an attorney versus the other clients that you've worked with?
All of the rules and regulations that apply to law practice, whether it's state or federal, or the profession, there are a whole lot of things. And that document that I referred to, that you had sent me before, Russell, that'll be part of the materials for this, really goes through all of that in detail. Most small businesses don't have anywhere near the requirement in terms of record keeping, in terms of just so many different aspects of the law that apply to a practice that don't apply to a retail or commercial business.
Also, I kind of a related question, which is, why do you think attorneys really haven't thought this through? Especially most small firms and solo attorneys. Why do you think, the state bar has had to issue this opinion, because it's gone untouched for so long and unrecognized for so long as an Achilles heel for most law firms? Yet, it's really not yet a codified rule in itself. It's not actually turned into an MCLE subject all by itself, although from the sound of it, it's probably going to wind up being an MCLE subject over time. It looks like they're seriously addressing that. But why do you think it's something that went unchecked for so long?
Because at the bottom line, they're business people, and their reluctance or just avoidance of it is no different than any other small business owner. I think the risk may be greater because of the kind of client obligations the practice demands, but it's no different than a doctor or a car dealer, for example, or
But why do you think attorneys have been so? Yeah, I mean, I know doctors. And my dad was a doctor, and he thought, a long time about how he would transition out his practice. And my uncle was a dentist, and he thought a long time about how he would sell and transition his practice. But I think most attorneys don't have that in their thought processes, where they're thinking all the time, or they're thinking way ahead of time how they would transition out of their practice. And I think it creates a challenge for attorneys, because their mindset is not normally based on if they would have to deal with a sudden change in their practice, whereas other professions do. And I was trying to figure out what your thought was as far as that goes.
This gets into the psychology of the profession, and how they're trained, the values that are instilled in them in preparing for the profession. I guess in a sense, Russell, it is puzzling, particularly, for example, for estate attorneys who are working with clients who are looking way ahead at what is happening in their life. That same thought process needs to be applied in a law practice. But I find that estate attorneys are not necessarily any more prepared than attorneys specializing in some other practice for that. I don't know if there's something characteristic of the training, development, etc., of the profession itself that would contribute to that. I see it as not a lot different than what I experience with almost any of the clients that I deal with. Some do think ahead of time, not a lot do. The one I mentioned, the first one that I mentioned, now she's accelerated her schedule because her husband just retired early, came home one night and said, "I'm going to retire after 2.5 years," and so her 7-year window is now a 2.5-year window. But she was thinking of it 7 years ahead of time. Now, it turns out she also has quite a business background. She entered the practice of law later in her life. And so she's had a broader range of experience than probably most attorneys do. But I see so many small business owners, and this applies to major corporations as well. A lot of the work I did here in custom executive education programs was major global corporations, and they have some of the same issues that they just haven't thought about succession planning, particularly in the C-suite, and the people who are really critical to managing significant parts of their business. So maybe it has something to do with just thinking about what does that mean? Talking about death, for example, is really difficult for people to do. In some cases, what I find with small business owners is that their business, and I would expect for attorneys as well, their business has been pretty much their life for 20, 30, 40 years. It's been their purpose. It really, whether they think of it or not, it really is their legacy in a lot of regards. And so thinking of stepping away from that, leaving that behind, leaves some real potential emptiness that I think can occur from that. One of the things that I do with all of my clients is initiate a discussion about what are you going to do when you leave your practice or when you leave your business. And the reason for that is, as I said, it's been their purpose in life for so many decades. The research, the Blue Zones research, for example, showed about 10 or 12 factors that are important to living a long life. But two of the key ones are having meaning and purpose in your life and having a network of a long support network that you build up over time. And I've experienced this with a former partner, that her father actually was an attorney, and he retired from work in Washington, D.C., and he'd been part of putting Glass-Steagall in place and retired from that. And she said within 2.5 years, she was watching his health decline. And she went to him and said, "Dad, you have got to find yourself a position." Well, he found himself a position as a general counsel for a small conglomerate there in Pasadena, and practiced for another 20 years after he left that. And the only reason that he stopped practicing was that his eyesight became sufficiently bad that he wasn't willing to put this big screen in front of his computer, and decided that was the time to retire. But he lived well into his late 80s, early 90s, rather than declining in his in his 60s. So it's just that avoidance of what can be a really difficult discussion, or a really difficult thing for probably most of us to think about, reasons to put it off and focus on the needs of the day and the demands now of your business.
And then I have one more question for you, and that is, how do you deal with a power struggle where one partner says, I should be the one in charge, and another partner says, no, I should be the one in charge, and then an associate says, I should be the one in charge? How do you deal with, everyone trying to grab the one piece of the pie on their way out? What do you do with that?
Well, that's why you want to do succession planning early, is so that you surface those kinds of situations. And that's also part of the reason that you really do a thorough job of documenting your role, your actions, your decisions, etc., so that you have a complete understanding of what's necessary for someone to step into your position if you're unable to fulfill it. And then you use that detailed list to assess. Ideally, maybe you've got two partners or two colleagues in the firm who are ideal successors to you. But whether it's one or two, what you want to go through is to take that set of roles, responsibilities, decisions, actions, etc., along with the characteristics that it takes to be a good leader in a firm, if that's your role, is a leadership role. And you do an assessment of the individual or the individuals who are likely, who you would like to identify as your successor. Where are they against that list of what they require to really step into that role? What kind of development is necessary to really prepare them to take a leadership role, to take a decision-making role, to have the perhaps the profession knowledge that's necessary in order to step into that kind of a role, and then use that to help you make a decision. But you've made the decision before that plan gets invoked, so that you help prevent those kind of power struggles. If you don't succession plan, that's when you get into that situation of I should be the successor, no, I should be the successor, etc.
Now, we've talked about California laws, but you can help people throughout the United States, I assume, with
Absolutely.
your skills.
Absolutely, yeah, and internationally as well. I mean, it doesn't have to be within the U.S. Although ideally, I like to meet with the business owner. I like to tour their business, or in the case of a practice, same thing. I'd like to tour the practice, and I find as a consultant working with both large and small businesses for just as a business consultant for 35 plus years, is I learn a great deal by just touring that business and understanding the environment in which the employees work, in which the business or practice owner does their work. One of my clients before the pandemic had what I would call a culture of interruptions. His door was always open, and he encouraged. I think it was about 15 or 17 employees, small business, but there were 3 key people: one that managed the shop floor, one that managed sales, and I forget what the third one did at this point. And they were free to interrupt him at any time if they had a question. And he would do the same thing. He'd go out on the shop floor and interrupt someone on the shop floor who was in the middle of an assembly process or whatever it happened to be. So part of what we put in place for him is and I wouldn't have seen that if I hadn't toured that facility and really seen how it worked and how and so on. And what we ended up putting in place for him was to really develop those 3 key employees to make the decisions, some of the decisions that he made, identifying what were the decisions that he wanted to continue making, and then scheduling a weekly meeting with each of those employees to understand what had been going on, rather than maybe interrupting them 2 or 3 times a day for simple questions, etc. So viewing the business and the practice is ideal, but there's an awful lot of that that can be done remotely. The attorney here in up north that I'm working with, I only see her office through the Zoom calls that we make. But I've learned a lot even with that on it. You know that old saying about the clean desk is a sign of a sick mind. You're going to learn a lot just by observing. Russell, thanks so much for your questions and for working through all of this. What I'd like to do now is really go over the document that has all of the details for a law practice that must be addressed in preparing for that transition from the planning attorney to the practice administrator, who is the successor attorney. So we'll bring up the document now that is presented as a potential contract of sale if the practice is being closed, but the work that must be done is every bit as pertinent when a practice is transitioned from one attorney to the successor attorney. So we'll now pull up that document and we'll go through some of the key items on that and emphasize some of the pieces that need to be emphasized.
So Don, I see here you've brought up an agreement to close the law practice in the future, sort of a sample agreement between what is known as the practice administrator and the planning attorney. And I'd like you to explain a little bit about how something like this works. Could you go over this agreement with us?
Sure, be glad to do so. And the terminology practice administrator here really is the succeeding attorney. And while this document says close the law practice, everything that's here is applicable to succession planning, to another attorney within the office, or to sale of the practice to another practice, etc. So what I'd like to do is go down through each of these things. I'm not going to go into a lot of detail of each of them, but really to identify what's critical here in this very long list of items. So obviously, one of the first one is that your successor attorney, planning administrator, has access to the office of the attorney doing the succession planning. So there's just a piece there about keys and security codes and things of that sort. Second is access to all of the financial accounts that might be involved with the practice. Whether it's a business account, it's some kind of an account that's set, accounts that are set up for clients, whatever, for a trust, etc. Every bit of that must be available to the successor attorney. And this really gets into some things such as where are all the passwords kept, how are they kept confidentially, etc. What are the practices of the practice to ensure that every bit of this is available should something happen unexpectedly to the planning attorney. And then there may be mail that is sent for the signature of the planning attorney, and so the successor attorney needs to be able to sign it in the planning attorney's place. The property relates to may be a building, It may be the equipment that the attorney has, etc. So there are questions here about how does that custody and control happen. Maybe that I mean, the attorney owns the building, that it may be leased to others, and again that lease responsibility needs to be transferred. Inventory and examination of files. There are a lot of paper storage in law practices, and are there access codes to these? Are they kept off-site in a warehouse somewhere, etc.? And how are those files accessed, but also how is permission transferred to be able to access these records, which may be kept in confidential storage? And then a very big part of this is notification to clients. And how do you notify the clients that a successor is taking place? And this is something that really requires more thought than just sending out a letter to all the clients and say your account's now being handled by successor attorney X instead of planning attorney Y, that there's an element of trust, of relationship, etc., that needs to be transferred as well. And ideally, that happens over time prior to any invocation of a succession plan. And then we've talked about transfer of files and how that happens, and being able to ensure that client confidentiality is preserved, etc. Storage of records, transfer of original documents. Maybe that there are due dates, whether it's a court date or it's a document due date, etc., that some of which may require an extension of time in order to complete the successor process and be able to have that completed on time. And it mentions here litigation notification to courts and others and so on. And again, these are all things that need to be understood at the time of transition from the invocation of the succession plan, so that particularly court appearances, etc., other things that have a legal obligation to complete at a certain time, are both made aware to the successor attorney, but also in time that they could take action to request extensions, etc. There may be obligations, of course, to agencies, the bar, other professional associations, and non-legal associations that the successor attorney may belong to and may have a significant role in, that also need to be either transitioned to the successor attorney, or perhaps transitioned within the organization to another within the organization. And then, of course, there's the billing, the fees, etc., that are involved, business expenses, creditors, all of those need to be understood and identified so that the successor attorney can properly handle all of this, or see that they're handled correctly. There's a real requirement here that the successor attorney be introduced to and build relationships with the personnel of the firm, whether that's an intern or paralegals or administrative assistant, etc. And really, how does that get transitioned from in a professional and satisfactory way to the from the planning attorney to the successor attorney? In the case of that I had mentioned before, of the attorney that I'm currently working with, she has this part-time attorney, and I said, what would happen if she were willing to take over your business? And her immediate response was, all my staff would quit. And the reason is that part-time attorney is just not prepared to manage that firm. There is continual frustration with the employees, that the attorney is very good with clients and very poor at timekeeping and all the record keeping and things that need to happen. And then things like obligations on leased facilities, on leased equipment. How are these? You were selling the firm, you might look at termination, but if you're continuing operation of the firm, then how do you transfer titles, transfer obligations on leases, etc. And of course, insurance, taxes, claims, all of those things need to be dealt with. They need to be known about first. So there's tremendous record keeping involved in just determining the succession process that's taking place. I think that pretty much covers it. Again, access to safe deposit box, representation of the planning attorney's clients. That's not something that you just send out a letter to each client and say, you are now represented by attorney X. That's all part of that very professional transition of relationships and trust that have to happen as part of this succession process.
Well, with all those things that you have to take into account, it's important. I can see why it's important to have someone like yourself help somebody plan all those things, because that's a lot of wheels and a lot of balls in the air, that you wheels in motion, gears moving, and balls in the air that you've got to, you know, round up and get your mind around. And I think a lot of attorneys haven't thought that through. So I think that's a very important part of what your role is.
Well, and there's overseeing that process is absolutely part of my role. Actually making the lists, keeping track of all of the details of this needs to be a practice administrator, not the successor attorney, but an administrator in that practice who has access to all of this, who can manage every bit of this. And it may be that it's necessary to actually bring in someone as a chief of staff, for example, for a period of time to really work through every bit of this and all of the details and document everything and ensure that every bit of this is handled professionally and confidentially. You don't want the list of passwords to be available to multiple people, for example, that it's every bit of this has particularly for a law practice, has a level of confidentiality that must be protected, both from others that might be involved with this in the transition process somehow or other, but also overall for the protection of the practice from hackers, from others that might find real value in hacking into the client's bank accounts, for example.
Yes. Well, thank you so much, Don. It's been very informative, and I think that our viewers will really appreciate all the input that you've given today and all the advice. And they have your contact information, so if they are interested in speaking to you about a succession plan, hopefully they will be in contact with you.
Good. And one of the things I'd like to add here is that I offer a complimentary exploratory discovery session to really get to understand their situation, what they've looked at, for them to get to understand more about what's involved specifically in their situation, and maybe some options that they hadn't thought about previously. So that's a complimentary discussion that I offer all of my potential clients.
Thank you very much for your talk today.
Thank you.